Okay. Give me a minute. Because I got to do this differently than I'm used to. Okay. Okay. This happened in Atlanta, and it is in Judge McBurney's court. This is not like, it's in Fulton County. It's not what's her name? I forgot her name. The stay out of Fulton County judge. Oh my god, I can't believe I forgot her name. It's not those type of cases. It's not like traffic and what is her name? I cannot believe I forgot her name. Judge McBurney does serious. Manning, thank you. Judge Manning. I cannot believe I forgot her name. Because, people, every time you hear Fulton County, people are like, oh, put him in front of Judge Manning. Let's see Judge Manning handle it. No, this is a murder trial. And unfortunately, I love her too. I absolutely adore her. Unfortunately, I do not know what happened to the dog. There is a dog involved. This man was out walking his dog, and there are 3 men involved. One is not charged. I don't know if that's because he flipped on the other 2 guys or what. I don't know those details. I also don't know what happened to the dog. I'm hoping the dog got returned to the family. But they killed the guy and stole his dog. I don't know if the murder was to steal the dog or if that was an unintended side of I don't know. The dog's name's Tequila. It's the cutest dog. It's so sad. I'm hoping that the dog was returned to the family. That's one thing I don't know. Maybe if it does go to trial, we will get to find out what happened to the dog. The wind, oh my gosh. You guys pray for me. North Florida is under like a hail, tornado, high wind kind of a thing right now. But they said like Tallahassee and Jacksonville, which is like 2 hours north of me. But then it said like the Swanee Valley Basin could get flooding. Yes, until we hear otherwise. Tequila's home with his family, fat and happy. Yes. So we're very, very close to the Swanee Valley Basin. We are not in the flood zone. Yeah, we are not in the flood zone. We are in the higher ground. The nursing home where I used to work, I used to be on call. Like if I was working whenever there was flooding, I would have to either be on call or stay sometimes because the bridge that went over the Swanee River, if it was flooding, and I worked with people that lived in the basin. So, In T-Town? What's T-Town? Tallahassee? Is that T-Town? So you're in Florida? Cool. Tallahassee. We're neighbors. Cool. Yeah, so I'm west of Gainesville. So, but we're getting wind. Like, it just whooshed and it scared the bejesus out of me. So, we probably won't get flooding, but we're getting the winds already. So, if I disappear, I don't know. Could be StreamYard, could be the wind. Okay. I have had trouble with, yeah, we do. We do. I've had trouble with recording things and trying to play them back. If I try to play them through StreamYard, like play the file through StreamYard, my sound and video's not synced. If I try to share my screen and play it, then the sound's not good. Tiny toilet down. Oh my gosh. Oh man. So let's give this a try, and I hope you guys can hear it and everything's fine. If not, I'll try to find it on YouTube again if it doesn't work, but hopefully.
New at 6, another man is behind bars tonight in connection with the shooting death of a man who was walking his dog in southwest Atlanta. The DeKalb County Sheriff's Office says deputies arrested Ricky Pierce on Friday. Pierce faces charges including murder, aggravated assault, armed robbery, and more. Brandon Baker was also arrested back in April, and he faces similar charges. Samuel Harris was shot and killed on Mitchell Street Southwest just after 8 p.m. back on February 5th.
There's Tequila.
Was stolen during that incident. Leah Harris, his wife of 15 years, described him as a family man with a calm spirit who had lived here in Georgia for 30 years. Authorities are still investigating what happened that night. If you know anything in this case, you're asked to call Atlanta police.
Okay, so there's the background. Did you hear it okay? Oh, and my cousin sent me this. I told her about this case, so she sent me this.
Have no fear.
Oh, wait, is it showing up? I'm not used to doing it this way. Nope. Here we go.
Have no fear. Justice shall prevail. The courts will decide. They say a man who represents himself has a fool for a client. Well, with God as my witness, I am that fool.
I was like, that's perfect. I'm keeping that. I'm going to use that. She's like, glad I could help. Okay, let me find the clips. I should have had this ready. I'm sorry, guys. I'm not used to doing it this way. Okay. Let's see. Okay, this is
for safety, but the court.
I should have edited it, and I didn't. Now I have to find. Darn it, Debbie. Why isn't it working? I'm pushing play and it's not playing. Oh, come on.
Handle this today. I just want to make sure. So it really was beyond your control.
It's a good kick to
Good
the head.
Lord, it's
for
loud.
safety, but the car was
I'm sorry, guys. I'm an idiot. Talk amongst yourselves while I figure out what I did wrong. I know what I did wrong. I didn't edit it. And now I got to go through the whole docket that day to find the case that I'm looking for. You know, last night I was thinking I should probably get up and go edit that. And I didn't. Oh, come on, you stupid thing. Why is it not playing? Well, now it's not even playing. Why are you not playing? You're downloading my computer, you stupid thing. There.
You are subject to the jurisdiction of the court.
There he is.
No. It's a good kick to the head.
Figure out how to do. I was going to handle Mr. Pierce. That you are subject.
Hang on, guys. I almost got it.
To your office. I'd get them after 30 days. I was going to. Okay. I was going to handle Mr. Pierce next. Okay, so.
Okay, I think I got it. I got it. But I thought you were short, Jilly. You're always saying how short you are. They knew you were coming. It was a short toilet. Tiny toilet town. Okay. Here we go. Okay.
We're going to do that. I just want to get the case up on my screen, and then we'll work through Mr. Pierce. Then we can turn to Mr. Cook. Sure. Yeah, probably the podium. I think that's going to be easier. I just need to find my checklist.
Okay, so the other guy, I think, I don't know for sure if they're going to be tried together or not. He does mention that the other guy is part of the case, but he's going to have a lawyer. This guy wants to go it alone. And Judge McBurney has the patience of a saint. He tries to talk him out of it. He tries everything he can think of to talk him out of it. And I love this judge so much. I watched a trial that he did on Law Talk with Mike's channel. And this judge is so good. I don't know why we don't watch him more often, but it's just, I don't know why. He's just a judge that not a lot of people stream. And he's He's a really, really good judge. He's nice. He's fair. He explains things really well. He's just a really good judge. And I don't know why people don't stream his court more often. But one day, I don't know why, we were waiting for something on Recovery Addicts channel. And we just came across this guy. And then the next day, Court Vibes did this. And I was like, oh, we've got to follow this from beginning to end. And so I grabbed it, and I've been wanting to do it. We've just been busy with other stuff. So since there's no court on the trial that we're watching, this is the day. We've got to do this. And I hope they don't talk. I mean, maybe I shouldn't say I hope they don't talk him into doing a deal, but I would love to see this. It's going to be hilarious. Of course, we need justice for this poor man. So maybe I shouldn't think that way, but this is hilarious. I'm sorry. It's
Give me 1 second.
What? What are you yelling about, huh? I'm working. Oh, I know why you're yelling. No, you're not getting my lunch. You're not getting my lunch.
Good afternoon, Mr. Pierce.
Good afternoon.
How are you?
Fine.
Good. I'm hanging in there. It's been a long day, but I'm sure it's been a long day for you as well. Whoop. Let's get your stuff all situated. Okay. Well, you've waved to him, but this isn't a place where we have that kind of conversation. You bet. Mr. Pierce, when we were last together, we had a conversation about representation, and you told me that you wanted to represent yourself. You didn't want a lawyer appointed, and you weren't going to be hiring a lawyer. And I said, we can have that conversation. That's an extended conversation, judge and defendant. And I'm ready to do that so that we can move your case forward. Otherwise, you're kind of stuck until we clear that hurdle. You have a right to represent yourself, but I need to make sure that you are knowingly invoking that right and intelligently, which is not me telling you you're not intelligent. I just need to make sure you understand the consequences of self-representation. So that's what I was hoping we could get through today. But I always want to start by saying what is on your agenda so we can see if there's anything else.
I'm a married state national, and I can't be represented by no attorney. But I have a lot of issues with me being a national that I want to address. You said you're going to let me hear me. You're going to let me address all my issues last time out here about me being.
Well, I did say that, but I said if you're going to address issues, I need to make sure you're representing yourself. Okay, but if we're going to do that, we have to have my conversation first. I'm required by law and by the Constitution to go through a few things to make sure it's appropriate for you to represent yourself. So you can want to do it, but I have to make sure it's appropriate to let you do it. I'll just give you an example. Let's say that you were deaf. That might make self-representation kind of complicated. You're not deaf, and so you can hear me and I can hear you. But I need to ask you a bunch of questions about your background and make sure you understand the consequences of being your own lawyer. If you assure me that you got it and getting all those things you want to represent yourself, I have to give you that right, and I will. And then you can share with me what your issues are. Okay? You ready to work it that way?
Yes, sir.
Excellent. Let me get one thing here. Get started. All right. Mr. Pierce, please tell me how old you are.
41 years old.
How far did you go in school?
11th grade.
All right. Did you ever get your GED?
Yes, sir.
When did you get your GED?
2017.
Excellent. Are you able to read English?
Yes, sir.
I know you can write in English because I got these, and you actually mailed me something that
Yeah, I wrote you a letter.
about 200 pages long. All right, so you can read and write, and you can speak English. Have you ever worked before?
Yes, I had several jobs.
Tell me what kind of work you've done before.
I worked for Dollar Tree when I got arrested. I worked for Airmark. I worked there for the Move Theater in North Carolina. I had my own landscaping business. I had my own record label.
He had his own record label.
You've had a bunch of jobs. Got it. All right, that's helpful to know. I appreciate you sharing that. Have you gone to law school?
I haven't gone to law school, but I have practiced. I have been studying law.
You've been studying the law. Tell me how you studied that.
Just reading, researching different case laws, sending out different statutes and codes and things of that nature.
Sure. Has all of your legal study been while you've been in jail, or have you also done legal study when you were out?
Both in and out.
Okay, got it. Have you ever watched an entire criminal trial before, start to finish?
I done been to trial before.
So you watched one then?
Yes.
Okay. What was that trial about?
On robbery. 10 years I just did on robbery.
So you were charged with armed robbery,
Yeah.
and that case went to trial.
Yes, sir.
So you were there from jury selection
all
the way through verdict.
To closing argument. I stopped before closing arguments and took 10 years.
Or you pled guilty.
Yeah, I tried right before they were finna come out for closing argument.
So you've seen 95% of a trial.
Yes, sir.
All right. You ever watched a trial on TV?
Yes, sir.
What kind of trial?
What the movie is so called? Law and Order.
Okay, you've seen that kind of stuff.
You've seen Law and Order.
TV stuff.
Yeah.
But you've been in a real one. You were a participant in a real trial.
Yes, sir.
How long ago was that trial?
2016.
Where?
Here.
Fulton County.
Yes, sir.
Who was your lawyer?
Kevin Farm. He's a judge now.
He is. That's a small world.
Yeah.
All right. Have you ever represented yourself in a criminal or a civil case before?
No, I haven't.
This would be your first time.
Yes, sir.
Got it. Have you ever gone to a doctor or a counselor to get treatment for any mental health issue?
No, sir.
Depression or bipolar or anything?
No, sir.
Okay. Tell me why you think you would do a better job representing yourself than a trained lawyer who went to law school and has done trials before would do.
Because by being a national, a lawyer only subject me to the jury.
Hold on 1 second. Yeah, you're good. So the court reporter needs to be able to take down what you're saying. What you're saying is important. So just don't rattle the change, and then she'll be better able to hear you. So you were telling me by being an American
state national, by me being a national, I can't be represented by an attorney because the attorney automatically subject me to the jury, the court's jurisdiction.
Okay. So my question was a little different. I hear you. But my question is, why do you think you would do a better job than a lawyer? It sounds like you may think a lawyer would do a better job, but you don't want a lawyer because you're worried that would subject you to the jurisdiction of this court.
I know for a fact it was subject to, because a lawyer is an officer of the court. By them being an officer of the court, it automatically subject me to the court's jurisdiction.
Okay. Well, indulge me for a minute and assume, you may think I'm wrong, but assume that I've decided that you are subject to the jurisdiction of the court. And you said, Judge, you're wrong. Okay. But I get to make the decision initially, and then you go to the Court of Appeals and they'll say McBurney was right, McBurney was wrong. But if I decided that this court has jurisdiction over you and this case and your co-defendant, do you want me to appoint you a lawyer? disagreeing with you. I am disagreeing with you, but we don't need to resolve that right now. I want to keep going with the discussion about representation. Before I get to the next question about the consequences of self-representation, if we fast forward and play this out, eventually you are either going to be pleading guilty in this case or you're going to trial. You're going to disagree about jurisdiction. I'm going to be very respectful and say, you know what? I hear you, Mr. Pierce, and you don't think I have jurisdiction or this court has jurisdiction over you. And I may be wrong about that, but we're still moving forward. Here comes the jury. We're going to do the trial. And so we're going through that whole process. And I may be told I'm wrong by the Supreme Court, and then I'll have to fix that, and then we'll fix it. But there'll be this trial. You're going to want to represent yourself, even though we're going forward with it.
Yes.
Okay. Do you know what you're charged with in the indictment?
No, I haven't had. I know what I'm charged, but I haven't had nobody come talk to me about this. I don't know what's going on. I don't know.
Well, that's because you said you don't want a lawyer. And so this is what we're getting into. No one's going to come talk to you about what's going on. I'll make sure you get the discovery, the paperwork in the case.
And when would I?
Well, it's complicated. We can get you the paper stuff pretty soon. But if I'm making this, I don't know what's in the case, but if there's video, let's say there's surveillance video, I can't give you that at the jail. It's on a disc. What are you going to do with the disc at the jail? You can't watch that. You don't have a way to watch that.
I would be signed a private investigator too, right? By me representing myself?
Nope. You don't get an investigator.
I do my investigations, and this part of the process.
Well, we're going to talk about that, but you don't. I mean, that's a reason to say, you know what? I will take a lawyer because that lawyer will have an investigator, and that investigator.
But can I have my own private investigator?
Hold your money. If you got money for it, you can hire anyone you want. But I won't be providing you money to go hire an investigator because you're saying I'm handling it myself. I got this. Mr. Pierce has it, which means your family would be, they could be helping you, or an investigator or something like that. Or there may be some way, and I can't teach you how to do it, where you could petition to get funds for an investigator, but that's not for today. One of the consequences of representing yourself is there isn't someone who comes and sits down with you and say, let's look at this discovery. Man, the way the police handled that looks like that's a problem to me. I've been a lawyer for 20 years. I've never seen a police officer do that. That's something a lawyer could tell you after he or she reviewed all the discovery. And you won't get you could look at it and say, this looks suspect, but you'd be making that decision without a lawyer helping you think about it if you represent yourself. You understand that?
Yes, sir.
Okay. But you seem concerned that someone hasn't already come to the jail to talk to you about what's in the indictment.
I'm not concerned. I wasn't informed on it. I know I was supposed to get a discovery package at least, or
not yet.
Or an indictment or something.
You will get it if in the end you convince me that I should let you represent yourself, then you will get all that stuff. But no one should have given you anything yet because we're on hold. Is he going to have a lawyer? Then we give the discovery to the lawyer who works with you on that. Or is he representing himself? Then we give the discovery to Mr. Pierce. And right now you're saying, I want to represent myself. And if we get through this conversation, then you'll start getting discovery. Let me tell you what you're charged with in the indictment. Count 1 charges you with murder and it alleges that you and Mr. Baker shot and killed Samuel Curtis Harris Jr. That's count 1. Counts 2, 3, 4, 5, and 6, and 7, and 8 are all what we call felony murder, which is you and Mr. Baker caused the death of Mr. Harris by being involved in a different crime: attempted robbery, armed robbery, aggravated assault, being a convicted felon, and having a firearm. Although that's just Brandon Baker. Brandon Baker apparently was a convicted felon at the time of this murder, and the murder was in February of last year.
Isn't he though?
Oh, you are too. There you are.
Yeah,
So you
I was
have
gonna say
felony conviction as well. You and Mr. Baker are charged with attempted robbery, and the allegation is, and again, these are just allegations. There's not proof of anything, but it's letting you know what you're charged with and what you'll need to defend against.
Okay.
But the attempted robbery allegation is that in February of 2024, you and Mr. Baker approached Samuel Curtis Harris Jr. on foot on Mitchell Street, right near here, with the intent to take his property. Count 10 charges you and Mr. Baker with armed robbery, saying, in fact, by using a gun, you took his property. In fact, what you took from him was a firearm. Count 11 charges you both with aggravated assault for shooting Mr. Harris. 12 is possessing a gun in connection with these crimes that I talked about. Same with 13. 14 is just Mr. Baker. 15 is you. And it says that on that date you had a firearm, but you were a convicted felon because back in 2010 you got convicted of something in Clayton County. And also, you got convicted of something here in Fulton County in 2016. I guess that's your robbery you were talking about. So the thrust is the allegation is you and Mr. Baker robbed Mr. Harris and shot him, and he died as a result.
No, not yet, Ardo. Hi, I'm glad you're here. Thank you for telling me that I muted it. I was eating my lunch and I knew the dogs were going to bark, but this is the first time I've ever done it like this, so I didn't realize muting my mic would mute everything. So thank you for that. No, he hasn't yet. I don't remember if he does that yet. But in the next video, he will ask about subject matter jurisdiction.
All of that. That's what you're charged with. Today is not the day to say, I didn't do it, it was self-defense, I wasn't there. That's your defense for another time. That's what you're charged with. So,
I have now?
Pardon me?
How many counts I have now?
It is...
Because I came here having 6 charges.
It's about 12 charges, but a lot of them overlap. 1 count of murder, several felony murder counts, because each of those other things I mentioned, the attempted robbery, the armed robbery, the aggravated assault, that creates a felony murder count. And then you've got a couple charges all for possessing the same gun, but because of your criminal history, it can be charged in different ways.
They got me charged with 3 different possession charges?
1 for possession of a firearm during the commission of a felony, and then 2 possession of a firearm by convicted felon, because you have a serious violent felony, your armed robbery, that leads to 1 type of possession charge, and the other, you've got this escape conviction out of Clayton, and that supports a different type of charge for possession.
And what that charge is?
It's possession of a firearm by a convicted felon, but it's a different type of convicted felon.
Got 2 possession of firearm.
You do. Yep. And those may not be good charges. I don't know. That's what you would talk to your lawyer about, or that you'd research on your own if you're representing yourself. All right. Do you understand what the penalties are for these charges?
Yes.
You understand that for this murder charge, you could be sentenced all the way up to life without parole, meaning you would die in prison.
Yes.
Same with all the felony murders.
Yes.
You understand that murders, you can't get more than 1 life sentence for the murders.
Say it again?
You cannot get more than 1 life sentence for the murders. You understand that? They'd all merge together. But depending on how the case played out, on robbery also, you could be sentenced up to life in prison. You understand that? Okay. And then the other offenses, they're lower sentences, but still serious. But the big one is murder with the possibility, not the guarantee, but the possibility of life or life without parole. You understand that?
Yes.
Okay. Are you a U.S. citizen?
Yes.
Do you understand that?
I'm not a United States citizen.
Well, I mean, I'm not trying to trick you. Were you born in the United States?
I'm not a United States citizen. I'm a American State national.
Okay. Tell me where you were born.
I was born at Grady Hospital.
All right, a Grady baby. That's all I need to know. There are a bunch of questions I can skip if you were born at Grady Hospital. If I decide that it is appropriate for you to represent yourself, do you understand that you don't get to change your mind partway through the trial?
What you mean?
Well, here's an example. In a robbery trial, you were able towards the very end to say, you know what, I want to plead guilty. I want to switch it up. I want to plead. Let's take this away from the jury. If you go to trial as your own lawyer and we get partway through and you realize, dang, this is harder than I thought. I don't really know what I'm doing. You don't get a call at time and say, Judge, find me a lawyer.
Oh, yeah.
If we start representing yourself, we finish representing yourself. Start to finish, you understand?
So if I represent myself, later on down, I can't have my family hire me a lawyer.
That's different. That's different. I wouldn't appoint a lawyer. You could bring in a hired lawyer whenever you want, knowing that if we're in the middle of trial, you can bring someone in, but we're not going to pause the trial. That person would have to jump down next to you and say, I'm ready to go. That person couldn't say, well, I need a week to get ready. But you'd be telling a lawyer, it's a strange assignment. You're going to come represent Mr. Pierce, and he's actually on day 2 of the trial. But some lawyers might be willing to do that. So, yes, your family could hire a lawyer tomorrow, next month, next week, next year. Hopefully, we'll be done with your case before then. But what you could not do in the middle of trial is say, Judge, I quit. You need to go get me a lawyer. Understand? Okay. Do you understand that in almost every instance, self-representation, you being your own lawyer, is a bad idea?
That's personal opinion, right?
It is a personal opinion. I'm giving you my opinion. I think it's a bad idea.
Why?
Well, I'm about to get to that. Do you understand that if you represent yourself, you are not entitled to any special treatment? There's not a Mr. Pierce rule like, hey, he doesn't know this rule. I'm not going to apply the hearsay rules to him because he doesn't know what hearsay is. You understand that? Whatever rules apply to the state, and if you had a lawyer, your lawyer, they're going to be the same rules for you.
Understood.
So if you are asking questions of a witness and you really, really, really want to get this exhibit in, Judge, I need to let the jury see this. If you don't know what questions you're supposed to ask to get it in, I don't say, ask these 3 questions. You got to figure it out on your own. And if you can't, then this doesn't come in as evidence. You understand that?
I thought you were supposed to admit the evidence before you start trial.
Well, sometimes it works that way. Sometimes it doesn't. It can work that way, but sometimes in the middle of trial, like, hey, you know what? I want to admit this now. But you don't get to ask me questions about how do I do this thing.
Oh, yeah.
If there's an objection and I sustain it, and you look kind of confused, you're just going to stay confused. I don't take a time out, have the jury leave the room and say, here are the 3 things you need to do to get this piece of evidence in. You understand that? That's one of the reasons why I think it's a bad idea, because I know you're smart and I know you've been doing some legal research, but I also know that you're not a trial lawyer. And so you might not know how to get something into evidence because you don't know which questions to ask. But you're aware of it. You know that's the rules. Do you understand, Mr. Pierce, that by choosing to represent yourself, you may miss possible defenses, legal arguments that a lawyer could make on your behalf to try to convince the jury to find you not guilty? Understand that?
Yes.
Yes? Okay. Do you understand that anytime that you fail to make what would be a valid objection, let's say the prosecutor is asking a leading question, and if you objected, I'd sustain it. If you fail to object, that evidence is coming in, and you don't get on appeal, say, wait, that evidence came in. Because if someone doesn't object, that's not anything that can ever be appealed. Do you understand that? Okay. Do you understand that I will not be making objections on your behalf? I may be thinking, this prosecutor is breaking every rule in the book with these questions. But they're rules of evidence, and it's not my job to hit the buzzer and say, that's not a fair question. It's your job to hit the buzzer and say, I object. You understand that?
Yes, sir.
I won't give you a little signal like a wink saying, hey, now's the time to object. You're on your own, sink or swim. You understand that? Okay. Do you understand that unless you take the stand and testify, none of the words that you say to the jury will be evidence in the case?
What you mean?
So lawyers are, you saw your trial. You said, hey, it ended before closings. That means you saw openings. Opening statement. The prosecutor got up and said, Pierce is a bad man. He did an armed robbery. You'll hear the evidence. He held a gun to someone, whatever they thought the evidence would be. None of that is evidence. All of that is the lawyer talking and saying, here's what you may hear. You'd be free to give an opening too. And your opening might be, I wasn't there. It was all Mr. Baker. You're going to hear evidence that I was in Louisiana when this crime happened. That's not evidence that you were in Louisiana. That's just you talking to the jury. And I'll be telling the jury that nothing that you say when you're giving your opening or that the prosecutor says while she's giving her opening is evidence. It's just...
See what I mean? I have never heard a judge explain so much and so clearly to a pro se defendant why it's not a good idea to represent yourself. He is bending over backwards to explain why this is not a good idea. And then the guy's just going, "What you mean?"
Some guidelines that the jurors could choose to follow as they're thinking about what the case is about. The only way you would get evidence in is if you choose to testify, or if you figure out how to admit exhibits.
Question.
Yeah.
What's the difference from me starting an open argument and the lawyer starting an open argument? It'll be admitted evidence if the lawyer start an open argument.
It's not. Tell the jury before we start the trial that you're going to hear from. If you represent yourself, I won't say the lawyer. I'll say you're here from both sides. You're going to hear from both sides an opening statement. That's not evidence. It is a preview of what each side thinks the case is about, but it's not evidence. And you didn't get to hear this because you pled out before then. But I would say, as would any judge, before closing arguments, you're about to hear closing arguments. These are not evidence. These are arguments from both sides saying, here's what the evidence showed, or here's what the evidence failed to show. Evidence only comes in through someone who's under oath on the witness stand or when an exhibit is admitted, which means if you wanted to testify to get evidence in, you need to take the stand. And the reason for that is that's because the state gets a chance to ask you questions too. Otherwise, you could just get up and give an opening saying, do it, or self-defense, all that kind of stuff. And you can say those things in your opening, but it's not evidence. And I'll tell the jury that. And so if you chose not to testify in your trial and you didn't put up any other evidence, then the jury wouldn't be considering what you said in your opening or your closing. You understand that? Okay. Do you understand that even though you know some of the law around criminal cases and this and that, if you choose not to have an attorney, you are losing the value of an independent perspective on this case. Someone who is not connected to what happened or didn't happen in this case. One value of an attorney is that that person comes in and looks at the discovery and says, hey, I'm coming in from the outside. I wasn't there. I don't know you. I don't know Mr. Baker. I'm telling you right now, this looks real bad. There's surveillance footage, and you're wearing a T-shirt that says Ricky Pierce, and your fingerprints are on the gun, and your DNA is at the scene. I'm making this up, but a lawyer could say, "Oh, look, Pierce, you need to work this case out because the prosecution is going to run the bus over you and back it up, and run it over you again with all this evidence." That's a lawyer having a hard conversation with you, if that's what the evidence was. But you also might have a good lawyer look at it and say, they have nothing on you. You were merely present. Baker had the gun. The video footage shows Baker shooting.
What just happened? Where did the sound just go? What just happened? Why did the sound quit? What in the world just happened?
That you are subject to the jurisdiction of the court. And you said, Judge, you're wrong. Okay, but no one should have given you anything yet because we're on hold. Is he going to have a lawyer? Then we give the discovery to the lawyer who works with you on that. Or is he representing himself? Then we give the discovery to Mr. Pierce. And right now you're saying, I want to represent myself. And if we get through this conversation, then you'll start getting discovery. Next week, next year, hopefully we'll be done with your case before then. But what you could not do in the middle of trial is say, Judge, I quit. You need to go get me. Prosecution is going to run the bus over you and back it up, and run it over you again with all this evidence. That's a lawyer having a hard conversation with you, if that's what the evidence was. But you also might have a good lawyer look at it and say, they have nothing on you. You were merely present. Baker had the gun. The video footage shows Baker shooting.
What happened to the sound? The sound was there. It was. What is happening? Dang it. Well, crap. Guys. I have no idea why the sound quit. It was there. I watched the whole thing. I don't know why the sound just... Darn it. Dang it. It didn't even get to the good part where he read his like 200 page or what. No, it wasn't only 200 pages, but. Okay, hang on.
If you're found guilty, then we need to make transcripts of everything, because all that goes to the Supreme Court for the appeal. Between now and your trial, we typically don't create transcripts unless, just as the dude died. That's great evidence for who isn't running the risk of going to prison. Lawyers are, you saw your trial, you said, hey, someone in, but we're not going to pause the trial. That person would have to jump down next to you and say, I'm ready to go. That person couldn't say, well, I need a week to get ready. But you'd be telling a lawyer, it's a strange assignment. You're going to come represent Mr. Pierce, and he's actually on day 2 of the trial. But some lawyers might be willing to do that. So yes, your family could hire a lawyer tomorrow, next month, next week, next year. Hopefully we'll be done with your case before then. But what you could not do in the middle of trial is say, Judge, I quit. You need to go get me a lawyer. Understand? Okay. Do you understand that in almost every instance, self-representation, you being your own lawyer, is a bad idea?
That's personal opinion, right?
It is a personal opinion. I'm giving you my opinion. I think it's a bad idea.
Why?
Well, I'm about to get to that. Do you understand that if you represent yourself, you are not entitled to any special treatment? There's not a Mr. Pierce rule like, hey, he doesn't know this rule. I'm not going to apply the hearsay rules to him because.
Wait, I went back too far, didn't I?
He doesn't know what hearsay is. You understand?
Instances, which is another reason.
Got a lawyer. It's called ineffective assistance. See, you know stuff, but you saying, here's what the evidence showed, or here's what the evidence failed to show. Evidence only comes in through someone who's under oath on the witness stand or when an exhibit is admitted, which means if you wanted to testify to get evidence in, you'd need to take the stand. And the reason for that is that's because the state gets a chance to ask you questions too. Otherwise, you could just get up and give an opening saying, I didn't do it, or it was self-defense, all that kind of stuff. And you can say those things in your opening, but it's not evidence. And I'll tell the jury that. And so if you chose not to testify in your trial and you didn't put up any other evidence, then the jury wouldn't be considering what you said in your opening or your closing. You understand that?
Yeah.
Okay. Do you understand that even though you know some of the law around criminal cases and this and that, if you choose not to have an attorney, you are losing the value of an independent perspective on this case, someone who is not connected to what happened or didn't happen in this case.
What do you mean by that?
One value of an attorney is that that person comes in and looks at the discovery and says, hey, I'm coming in from the outside. I wasn't there. I don't know you. I don't know Mr. Baker. I'm telling you right now, this looks real bad. There's surveillance footage and you're wearing a t-shirt that says Ricky Pierce and your fingerprints are on the gun and your DNA is at the scene. I'm making this up, but a lawyer could say all this and say, look, Pierce, you need to work this case out because the prosecution is going to run the bus over you and back it up and run it over you again with all this evidence. That's a lawyer having a hard conversation with you, if that's what the evidence was. But you also might have a good lawyer look at it and say, they have nothing on you. You were merely present. Baker had the gun. The video footage shows Baker shooting the guy, and you're standing there looking as scared as the poor guy who got shot. I don't know what the evidence is. I do know that having your own lawyer means someone who is independent, who isn't running the risk of going to prison, can look at this and say, this is a good case for you, or this is not a good case. You will never get that independent assessment of the strength and weakness of the state's case if you represent yourself.
Right.
You understand that?
Yes, sir.
Okay. Do you understand that the prosecution will be free to bring in the most experienced attorney it wants? I won't say, hey, Pierce isn't a lawyer, so you need to bring in a brand new prosecutor who's never tried a case before, so it's more even. Understand that?
Yes.
They could bring in the big guns, and that's your problem and not anyone else's. Understand?
Yeah.
Okay. Do you understand that I will not ever tell the prosecution to go easier on you as the opposing side because you're not a lawyer?
Yep.
I'll expect them to treat you as respectfully as they do defense attorneys because you ought to be. You're the other side, but they aren't going to need to pull punches with objections or anything like that. If they think something wrong has happened, they're free to object. You understand?
Yes.
Okay. Do you understand that if you are found guilty at trial, you will not be able to argue on appeal that you were a bad lawyer for yourself?
Understood.
Because that's a claim that a defendant can always make if he's got a lawyer. It's called ineffective assistance. See, you know stuff, but you cannot say I was ineffective, meaning Ricky Pierce was ineffective.
Right.
You may have been very ineffective, but you don't get to argue that if you're your own lawyer.
Understood.
All right. You're understanding all the stuff you need to. Do you understand that you will not get extra time to prepare for trial just because you're representing you're going to have plenty of time. Trial's not tomorrow. But if you say, you know what, I need a year to get this done, I'm going to say, no, you don't. You're not going to get any more time than I would give the lawyer that I would appoint to represent you. Or if you hired a lawyer, I wouldn't give that lawyer a year to get ready. There's a family that's grieving because of a loss. You're sitting stuck in jail. And so we need to move this case along. I'm not going to rush it, but I'm not going to go slowly just because you represent yourself.
Understood.
All right. Do you understand? And this is something we've already talked about, but it's important we cover it again. Your ability to investigate this case and do legal research will be very limited by the fact that you're choosing to represent yourself and you're stuck in jail.
Yeah.
You got that? You appreciate that's a disadvantage.
Yeah.
But it's a disadvantage you're willing to eat.
Yes.
Okay. All right. You understand, if you had a lawyer, you hired one or appointed one, that lawyer would not be stuck in jail with you. That lawyer would be able to go out and you could say, hey, you need to go interview Fred Smith. And they'd try to find Fred Smith. And they'd have an investigator who could try to find Fred Smith. You understand that?
Yes.
You're going to need to figure out how to do that on your own. Right? Okay. Now, if you had a lawyer, you understand that that lawyer could give the opening statement for you, could do the jury, we call it voir dire, but questioning jurors in advance when you're doing jury selection, could interview witnesses, subpoena witnesses, prepare jury charges, do closing arguments, cross-examine the state's witnesses. A lawyer would, should, and could do that for you if you had a lawyer. You understand that?
Yes.
And you won't have any of that if you represent yourself.
Yes.
All right. Has anyone threatened you to get you to waive your right to a lawyer?
No.
Has anyone promised you something to get you to waive your right to a lawyer?
No.
Mr. Pierce, do you want to represent yourself, at least for now, in this case, understanding that the only way you can undo that is by saying, I hired someone. Here's this lawyer for me, because otherwise you're telling me, no, I got this. You understand that?
Yes.
And do you want to represent yourself?
Yes.
Okay. Well, I find, and I'll get this in writing and enter an order to that effect in the docket, that you're aware of the charges against you, murder, felony murder, aggravated.
What I don't understand is he said, he doesn't say Sov Cit. What is it? American National? He said that his family, most of his family, they've always been American nationals, but he had a lawyer last time. So why did he have a lawyer last time and he doesn't want a lawyer this time? What changed?
Aggravated assault, armed robbery, etc. The consequences you face if you're found guilty, up to life without parole. The advantages of having a lawyer, outside investigation, independent opinion, legal expertise, etc. The disadvantages of having no lawyer, hard to investigate, hard to do legal research. But I find that despite all those things, you have made a knowing, intelligent, as in you get it, and voluntary, no one's forcing you, waiver of your right to counsel, and you are exercising your right to represent yourself, and I'll grant you that right. Any questions about any of that?
No, sir.
Okay. We got, so two things. One, I'll make sure that, Mr. Abate, is this your case? Okay, that's your prosecutor. I'll make sure Mr. Abate gets to me as much paper discovery as they've got. Again, there's often lots of digital discovery. I'm making this up. I don't know what's in the case, but let's say your cell phone was seized. They might have done a cell phone dump, and there's a big old file that lists all the pictures and texts. And sometimes, maybe not in this case, after something happens, Baker texts to Pierce, uh-oh, I can't believe we shot that guy. And Pierce says to Baker, hey, we need to not talk about this anymore. I heard the dude died. That's great evidence for the state, but that's digital evidence. And so that might not be something that can be handed to you to look at in jail. So what you'll get is all the paper discovery as well as a list of what is the digital discovery, body cam footage, surveillance footage. And then you would let me know. We'll have a status conference so I can see how things are going. Hey, Judge, there's some things I need to watch. And we would set up a time when you could be here and there'd be a laptop and that stuff would be there and you could watch it and take notes, whatever you need to do. It's not convenient for you, but that's how it works when you are representing yourself and you're stuck in jail. So my answer is not you can never see it until trial. It's just we have to develop a little bit of a workaround. And so you'd be watching it here. You can't just watch it anytime you want. We'll set up a specific time and that's how you digest it. Okay? I'm not saying there's any digital discovery, but if there is, that's how we do it. So I'll get from the state the discovery. We'll figure out how to get it to you. Either we'll bring you over here and hand it to you. That's often my preference because it's on the record. I see you getting the discovery, or through the sheriff's office, we'll get it to you. Are you at Rice Street?
Yes.
Okay, we'll get it to you at Rice Street. Mr. Abate, what would you say the ratio is in this case of paper discovery to digital discovery?
A lot of discovery.
Okay.
Like Mr. Baker's cell phone extraction. And there's a lot of video surveillance, some of which this defendant, Mr. Pierce, is seen in high definition video shooting the victim in the head.
Okay, so there are things he'll need to see.
Yeah.
Okay. When you generate the paper discovery, would you please include, you don't need to list the description of each video, but 9 surveillance footage, 9 surveillance videos, 2 body cams, whatever the generic count is. So Mr. Pierce knows, and then he can be keeping track. Wait a minute, I've only seen 1 body cam and it says there are 2. We can sort that out. Thank you. So you'll get the paper discovery, and then clearly we're going to need to figure out a time when you can come here and watch it. You get to watch it privately. The prosecutor's not going to be there while you're doing it because you may have a reaction to it, and take notes, whatever you need to do. That's number 1. Number 2, are there things that you think we need to talk about now, or now that you represent yourself, are there instead things that you want to get in writing and file as motions?
Yes, I have 2 motions that I want to file. I have them wrote up now in my thing, and there's a lot of issues that I have to address as far as with me being a national, just putting it on a record for my benefits.
Okay, so let's do that. Let's do 2 things. 1, I want you to put on the record, we want to just do it. You're free every time we're in court together to remind me that you're American State National and you don't think that there's jurisdiction. But what I would ask you to do, you're going to share, it sounds like a fair amount right now, to get it on the record. We only need it on the record once because you will have made that record. And then in the future, all you need to do is say, hey, I rely on the record I made. You don't even need to state the date, but that I made before about my objection to jurisdiction or whatever you want to call what you're about to share. So I'll always let you make a record, but I will push back a little bit if next time I see you, like, hey, I need to make that same record again. No, you don't. You made it, and you only need to make it once. And then there's a transcript so that if you need to take something up on appeal, they only need to read it once. All right?
Would I get transcript from every court proceeding? Or how do that work? Do I have to file for it?
So
automatically get it to me. I'm representing myself.
So every time Ms. Rivers is taking something down, we can create a transcript. We don't immediately generate transcripts because, for example, if you go to trial and you're found not guilty, we don't need to create a transcript of any of that because you're done. You go home. If you're found guilty, then we need to make transcripts of everything because all that goes to the Supreme Court for the appeal. Between now and your trial, we typically don't create transcripts unless, just as an example, let's say we had a suppression hearing and a lead detective testified and talked a lot about the work that she did on the case. Everyone wants a transcript of that because she's going to come back at trial. And if her story changes, then someone wants to say, wait a minute, you were in court 2 months ago and you said Mr. Pierce was wearing a blue shirt and now you're saying he's wearing a red shirt. Which one is it? The jurors are wondering, why is this detective changing her story? But things we're saying today, that kind of transcript we'd make only if you're found guilty and we need to push stuff up to the Supreme Court. But it is being preserved if Ms. Rivers is here and doing what she needs to do, which she is. So why don't you briefly share with me the things you want to get on the record?
Your Honor, let the record reflect that I'm American State National, which is a private American. I'm here on a special appearance to administer the affairs of the All Caps Trust. I am the living man, Ricky DeMond Pierce, and not the All Caps legal fiction, corporation, or dead entity. I stand on the land and soil jurisdiction, and that's the highest jurisdiction on the man. This is my oral request for me changing the court's jurisdiction over me here today. I have not contracted with the court in any kind of way, and I don't plan on contracting with the court in the near future. I have been forced to come here against my will and God-given rights under threats enforced by your government officials, which is kidnapping. Your courts have no jurisdiction over me, and I stand on the land and soil jurisdiction to have proof of it when I came to court on January the 30th, 2025. Your courts plus in Louisville versus Motley, if any tribunal finds absent of proof of jurisdiction over a person and subject matter, the case must be dismissed. Your court's jurisdiction is the jurisdiction of the sea, which is the Admiralty and Maritime Laws, which is also a military tribunal, and the courts are known as a ship of war, a privateer, or a battleship. I am under public law, which is common law, which is also the law of the land, natural law, God's law. I have God-given rights that can't be violated, and the courts are under Admiralty and Maritime Laws, which is a foreign law of the sea jurisdiction. See Article 3, Section 2 of the United States Constitution. And no living people live there on the dead.
You forgot the law that said thou shalt not kill. What did I just do?
Law 150,000. T, Ford 1, which is the corporation government.
Dang it!
A lot of video surveillance.
You need to figure out how to do that on your own, right? So Mr. Pierce knows, and then he can be keeping track. Wait a minute, I've only seen one body.
Dang it, I went to pause it and I accidentally hit the wrong part of the video and I went back. I'm just batting 1,000 today, y'all. Go back to your
question, your oath of office, Your Honor. The notice that Trump sent out.
Then we need to make transcripts of everything.
Entities, which is another reason why you have to dismiss this case, because the living cannot be judged by the dead. Another problem the courts have, because my God-given right says I have to be tried amongst my peers and a jury of living people, which is American state nationals, and also can't happen because our nation is not under the court's jurisdiction, and we're not showing order because they hold a higher jurisdiction. In the original Constitution, Section 3, Article 3, Section 2 states that the United States, the corporation judicial power is under Admiralty and Maritime jurisdiction. And I am under the land and soil jurisdiction, and I have gave courts proof for this when I came to court January the 30th, 2025. I also mailed out my executive letter, the notice that President Trump sent out January the 4th of this year, letting all patriots know that these laws have been dissolved due to breach of oath, due to fraud and breach of oath for office. And I also mailed out for copy of my certified mail. I mailed out certified mail and have been received. I am also requesting your oath of office, Your Honor. The notice that Trump sent out goes as follows. Notice to patriots, date January the 4th, 2025. This is to inform all patriots that effective immediately, our government and government corporations are hereby dissolved due to breach of oath. Additionally, our statutory and foreign laws are also dissolved. The only legal framework that remains in effort are constitutional law as outlined in Article 61 of the Magna Carta and established common law. This directive is especially for corporate bodies and government workers. Any government corporate body, including police, judges, lawyers, and any individuals operating in these capacities must cease operation immediately. Those who continue to operate after this notice will be liable for prosecution for fraud and breach of oath. It is imperative that all government workers comply with this directive. Failure to adhere may result in serious consequences and even including potential military actions. I declare on the penalty of perjury on the public law of the United States of America that does your government from without the United States of America, the de facto government, and without the United States of America, the corporation territories. I reject, renounce, and remove all powers of attorney granted to me or issued under my name prior to this day. My birth certificate was the only contract that subjected me to these laws, but the birth certificate contract is void because I was only a minor and had no knowledge of this contract when it was constructed, which makes this contract void, which means the court lacks subject matter jurisdiction over me. I am no longer.
His birth certificate is void because he was only a minor.
An employee of the government, which is the corporation government. I declare on the penalty of perjury on the public law of the capital T, United States of America, the does your government, that I reject, renounce, and remove any and all alliance to any king or prince, any foreign state, any foreign government or flag. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself to any incorporated entity at all, but including but not limited to any incorporated church, synagogue, masjid, or temple. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself of any foreign state, foreign sovereign, or separated myself from my birthright political status as American state national. I declare, publish, and affirm on the penalty of perjury on the public law of the United States of America that I am a lawful inheritor, acting with full rights and authority, responsibility, and honor now and always while my tenure on earth shall last. I, the living man, Ricky DeMond Pierce, affirm and declare that I have returned to my lawful birthright political status as a Georgian, and I have copyrighted and trademarked the all caps name, which is a trust and not the living me. I have occupied my executive office and never gave the courts any permission to use the all caps name, which is fraud. I have over 40 violations that the courts have committed upon me and my God-given rights as American state national. And I have counted over $800 million in violations over the time that I have been incarcerated at Fulton County Jail these 150 plus days. And it's only adding up as I sit in Fulton County Jail against my will and consent. And they are as follows. 1, these are all combined municipal and territorial notices of violations against Americans with failure to perform any and all.
You can't see the judge. The judge is over to the left. The top box, the top left box, the judge is off screen to the left. You can't see him. I put his picture on the thumbnail because he's got such a wonderful voice. I wanted to know what he looked like, so I found a picture. He said over $800 million that they owe him because he's been in jail. And I hope I didn't miss it. I screwed up and actually went back when I tried to pause it a while ago. And I hope I didn't miss it, but he itemizes and he comes up to over $1 billion of what they owe him.
All occurrences listed below in this section starting at $10 million. A, notice of claim of sole relief and remedy. B, notice of violation of the Lanham Act, attempted attachment and seizure of unregistered trademarks, Title 15, Section 1125, 8 and 11. Notice of violation of admiralty and maritime and prior cases, Title 25, Section 1331, 1, 2, and 12. D, notice of violation for special maritime and territorial jurisdiction of the United States, Title 18, Section 7, 1, 3, 8, and 13. E, notice of violation of the Postal Accountability and Enhancement Act of Title 39, Sections 1-3908 and 3621-3591. F, notice of violation of presumption of the Public Vessel Act, Title 46, U.S.C.A. Appendix, Section 781 through 790, as originally enacted. G, notice of violation of the False Claim Act, Title 31, U.S.C.A. Sections 3729A and 7. H, notice of violation of the Foreign Sovereign Immunity Act, Title 28, Section 1602 through 1611. I, notice of violation of the United States Statute at Large Act, Title 12, Section 411. K, notice of violation of the Geneva Conventions by the United States Department of Defense.
Mr. Pierce, I'm going to just pause you for 1 second. You were on K. How many letters? I want to make sure
No, I'm
you're almost done, because we're getting into international stuff, and that's getting a little far afield.
All right. 2, private easements fee schedule. Penalties for private use, $250,000. These fees will be mandated upon the informant listed on the warrant, citation tickets, arrest warrants, detention orders, and seizure orders. Compulsion to produce trade name or other identification materials. A, name, $50,000. E, fingerprints, $200,000. F, Photographing, $200,000. G, DNA, $5 million. Blood sample, $5 million. Personal property, trespass, carjacking, theft, interference with commercial trade. M, color law, $150,000. N, implied color law, $150,000. T, fraud, $1 million. U, fraud upon the courts, $2 million. BB, stimulating legal process, $1 million. Use of trade name and copyrighted protected material on a threats, duress, and or coercion. Name written by a informant, $250,000. Miscellaneous material written by a informant, $500,000. Court appearance fee schedule. These fees must be paid immediately after my case is finished. Failure to pay fines and fees result in an additional fee of $5,000 for breach of contract. Demand for appearance in court. My appearance on the protest and duress per hour, 1 hour minimum, $75,000. Use of trade name material.
How many more pages do you have?
I have quite a few.
Okay, so I'm wondering if, and I'm not going to curtail you too much, but you'll be able to file that, which will make it even more of a record if you want it to be filed, or you could give it to me and I'll file it for you. But that's up to you. What I don't want to do is I want to make sure we're moving your case forward, and this is pretty lengthy. It might be more efficient to have it filed into the docket so that we actually see, hey, there it is in the computer system.
I really need to get it on the record, and I need to file a motion to be able to address these issues also. I have the motions already wrote. If you give me a little time, I can get through it pretty quick.
Well, I don't want you to read too fast because Ms. Rivers needs to be able to take it down. Would you say we're more than halfway through, or are we not more than halfway through?
Yeah, we're halfway through.
Exactly half or more than half?
Exactly half, because it's 20 pages. I'm on 11 now.
Okay. Well, let's go. Don't read too fast, but don't read too slowly.
Trespass and failure to act fee schedule. Use of trade name material, name on a protest and duress, $25,000. Miscellaneous material, $25,000. Time uses for court appearance, 30 minutes on a protest and duress, $33,500. 60 minutes on a protest and duress, $75,000. 90 minutes or more on a protest and duress, $100,000. Trespass and failure to act fee schedule. Trespass by public officials, police officers, judges, detectives, attorneys, corporations, and other fictitious entities, as well as any other who desire the contract. A, trespass on American homestead land, $10 million. C, failure of attorney to file requested FARA form, $1 million. Failure to accept American State National card, $1 million. Failure to honor God-given rights, $20,000. Failure to honor oath of office, $50,000. Failure to honor constitutional oath, $50,000. Failure to honor written and oral word, $5,000. Failure to honor a bond/no bond, $5,000. Detention from free movement and or cuff per hour, 1 hour minimum, $75,000. Incarceration per hour, 1 hour minimum, $75,000. Failure to follow federal and or state statutes, code, rules, and regulations, $50,000. Failure to set a claim upon which relief can be granted, $25,000. Failure to present a living injured party, $100,000. Total damages for each line set forth in a above schedule will be assessed as the total amount of damages as set forth herein times 3, for a total of all damages added to a 3 times the damage for appearance and other additional damages, for a total of $1,019,631,000 US dollars.
$1 billion. You're at to the B.
Yes.
Okay, that's a lot of money.
And that's just for the amount for me being incarcerated these 120 plus days. Your Honor, all laws are commercial, and all laws are not laws. The code, statutes, mandates, regulations, and all the rest. And I'm a private American or not under commercial law. What's legal aren't law, Your Honor, and what's law aren't legal. And Your Honor, ignorance to the law is no excuse, and that goes on both ends, mine and yours. This declaration is valid, true, correct, and complete in all jurisdictional law, air, land, and sea. Your Honor, let the record reflect that if you are against this, this is warring against the Constitution. And warring against the Constitution is called piercing the veil. And piercing the veil is called treason. Treason is punishable by death, and there is no remedy for treason. Also, in Orange versus Independence, also the court have no immunity from persecution when violating the constitutional right. I am under the United States of America, the Dutch government, the Confederation of the States.
Mr. Pierce, there's one phrase you've used a whole bunch of times, and I don't understand it. The what government?
The Dutch government.
What is, spell that?
DEJUNE, space JUNE, Dutch. DEJURE.
Oh, got it. Okay.
Dutch.
Yep. Thank you.
Okay, which is the Confederation of the States. And the Federation gave the United States, the corporation, the de facto government, the power to operate out the 10 square miles, which is in Washington, D.C. And any laws outside of Washington, D.C. is commercial. And private Americans are not under commercial laws. We are under public law, which is common law. My God-given rights has been violated by being forced to give my DNA, fingerprints, eye pattern, and blood DNA against my will. I never consented to them arresting me or detaining me. After I put them on notice of my political status. Your Honor, United States, and no corporation can interact with a living man under another corporation. Your Honor, it states that every man is independent of all laws except those prescribed by nature. No man or woman is bound by any institution formed by his fellow man without his consent. See case law, Cruden versus Neal, 2 N.C.338, May term 1796. Your Honor, in 1845, the then Pope and the British monarchs, both of whom were honor bound to act as trustees for United States Trust, and both of whom acted in gross breach of trust, agreed that the American experiment was not working. The whole idea of self-rule was antithetical to the idea of divine rights of a king's supremacy. So they signed a secret treaty of Verona and agreed to undermine the American government. The British Monarch Commercial Company, which controls the bankers and lawyers, issued license to lawyers to act as private.
What does the Revolutionary War have to do?
That's why the Bar Association requires license. Acronyms for bar mean British Accredited Register. Anytime we see the word license, it means that someone in a position of rulership is giving someone else permission to do something that is otherwise illegal. In this case, the king gave the members of the Bar Association permission to act as privateers against American commercial vessels. Because the jurisdiction where they attack us is international, admiralty, and maritime commercial laws. And that's why you see the gold rings around the flag, around that war flag. Because
I'm really bad at geography, but I don't think the ocean's anywhere near Atlanta.
The war flag is a war flag representing that the government is at war with the citizens. See 1864 Naval Agency and Distribution Act. Again, also, the United States was incorporated by the Pope, and the laws we are bound by are foreign laws from Great Britain, which means that the United States, the corporation, got Americans bound by laws from Great Britain, which is also illegal. That's why, again, you have BAR, which stands for British Accredited Registry.
What page are we at?
What am I supposed to do? I'm closing now.
All right.
I am 1, change from jurisdiction of the courts. I have a high jurisdiction. 2, I am demanding to see the state of Georgia to show up in proper persona. This must be made by self and not an attorney. 3, I am demanding that the courts present a living injured party because our citizens are considered dead entities, corporations, legal officials, and artificial persons. 4, I am requesting the judge oath of office and the first and last name of every court official in this courtroom before we proceed. I am demanding to see who gave the court's permission to use the all caps trust, which is a copyright and trademark. And I'm putting the courts on notice that I have occupied my executive office again, and I'm standing in my full capacity as American State National, and I hold the highest court here today. I am demanding you give me a full relief for my case by either dismissing this case or giving me a bid bond signed and paid through my all caps trust. I am also filing an order of pro se ex parte with prohibition to dismiss my case for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction. Your Honor, the petitioner, case will not be or not be.
I told you guys this was hilarious. Now do you see why I was so upset when the sound went out on mine?
being handled in the proper courts, which is common law courts. I, the petitioner, was not put on notice by a state-appointed attorney that my case was not handled in the proper courts. I, the petitioner, never signed a contract to be subject to the jurisdiction of the United States and or the District of Columbia. Again, the birth certificate and Social Security card are voidable contracts that was constructed when I, the petitioner, was a minor. So these contracts could have not been knowingly, voluntarily, or willingly consented to because as a minor, I, the petitioner, lacked the capacity to do so. Again, I am making a clear and unequivocal demand to petition the state to show up in proper persona. The state is a legal entity, and a legal entity is an artificial person. And an artificial person is a corporation, which cannot appear in proper persona. See case law, Penhollow versus DOANES. This vagueness doctrine may invalidate criminal law for two independent reasons. First, it may fail to give a proper kind of notice that will enable ordinary people to know what kind of conduct to prohibit. Second, it may authorize and even encourage arbitrary and discriminatory enforcement. Your Honor, a basic principle of due process that a law is unconstitutional if its prohibitions are not clearly defined. Plus, I, the petitioner, cannot owe a debt in a bankrupt nation, and no title of nobility shall be granted by the United States. See the United States Constitution. Again, Your Honor, I, the petitioner, cannot have a fair and impartial trial when the judge, the jury, the bailiff, the district attorney, and public defender all work for the state and are one and the same. See the case law, the Maggie Hamlet case. Your Honor, the Constitution is a chapter of negative liabilities, liberties, excuse me. It tells the state to let people alone. It does not require the federal government or even the state to provide services, even so elementary as maintaining law and order. See case law ID, period, CF.OLMSTEAD versus United States 277 US.438 and 478 1928. And again, Your Honor, any judge or magistrate who does not comply with his or her oath to the Constitution of the United States wars against that Constitution and engages in acts of violation of the supreme law of the land. The judge is engaged in acts of treason. See case law Cooper versus AURON, 358 US.1,78S.CF.1401 1958. Your Honor, the authentication of my birth certificate signed by the Secretary of State, the Secretary of Washington, D.C., and the Governor of Georgia is admitting that the government made a mistake by making me to abide by a void contract and subjecting me to the jurisdiction and laws of the government when I had no knowledge of this.
He just said the first thing he said that was true. His birth certificate was a mistake.
A contract, and was too young even know that this contract exists, that the government tricked me and my parents into without our knowledge and consent. And the courts have a copy of my birth certificate authentication also. Your Honor, I am a private American, which is American State National, and cannot be represented by a bar attorney because an attorney is an officer of the court and will automatically subject me to the court jurisdiction.
And I hear you on that, which is why we had the first part of our conversation, and I've concluded that you've got the ability to and the desire to represent yourself. We'll do that. I appreciate you making that record. As you and I agreed, you won't need to do that again. You've now made all those objections, made it very clear that there's $1 billion plus, and I get it that number is increasing. Every day you're in custody and people are trying to contract with you when they shouldn't, all that. You've made a healthy record of that. You're welcome to file things now because you are your own attorney. You can now file things of record into the docket. But when we see each other again for whatever the next court event is, we can use a shorthand where you can say, I renew the objections that I made on the record when I was last in court. And that way you're not going to need to break your vocal cords by going through that again. But that was very thorough, and I appreciate you making that record.
So is I can leave these motions here today?
So This one time, I'll take responsibility for filing things for you.
I'll wait because I still have some other.
You want to do more work on it?
Yeah.
Okay. There's a way for you to file things from the jail, and they ought to tell you about that, but you can get things to the clerk's office. Don't mail them to me, because if you mail them to me, I'm not the clerk. They won't get in the docket. They go into my inbox, and I've got my Pierce collection. You should also know if you send things to me, I probably need to send them to the prosecutor as well, because we can't have what we call ex parte conversations. In the same way that the prosecutor can't call me and say, let me tell you what Pierce did. That won't happen. If Mr. Abate wants to talk about this case, you need to be in the loop as well. And so we'll bring you over here, or if it's real simple and technical, we'll get you in a Zoom booth so you can see and hear. But if it's anything substantive, you'll be here in person in open court for that. Okay? So what I see as our next steps, then I'll see if the prosecutor has anything else, and I'll see if you have anything else, is that I'm going to get a scheduling order in that gives a deadline for Mr. Abate to get together the paper discovery and then a list of what the digital discovery is, and we'll figure out how best to get that to you. I need to enter an order that says you get to represent yourself, so that's in there, and then we move forward.
Okay, cool.
What about you? Yeah.
Last time I was here when I went to trial, they had where I went to the law library and look at video footage. That's not possible anymore. Well, yeah, I
don't know. Meaning you went to the law library at the jail,
yeah,
and you were able to
They had an officer supervise me to watch the video.
Okay, why don't you ask? That's a question you need to ask the folks out there. I don't control the sheriff's security protocol. They may still do that. They may have cut it off because someone said it's video footage and instead it was an adult movie or something. And that's not you, but someone may have done something that abused that privilege. So ask, and if the answer is there's a way to do it, we'll make it happen. What I do know works, because I did it the last time I had a pro se defendant, is that he came here and we had a laptop. The prosecutor brought in a laptop and said, here's the directory, here are the 5 videos. The prosecutor went away and you hit play and you got to watch them. Took whatever notes you wanted and then you went back. So worst case scenario, we'll do that. But if you figure out there's a way to do it at the jail, then we can talk about making that work.
Who I need to I think I need to contact the sheriff office, the sheriff or something.
It would be someone at the jail. I don't know who you talk to if you want to go to the law library or if you've got a headache and you want a pain pill. I would talk to staff out at the jail. Hey, if I want to do X, is there a way to do it? If they say there's not, then we got to do it over here.
All right.
Okay.
Understood.
Any other questions?
No, sir.
Mr. Abate, what do we have from the state?
So on the last issue you just, or Mr. Pierce just raised, I don't believe the jail does that anymore.
I don't either, but
the USB and the or CD, they just don't allow that kind of what they would call contraband at this point. So we can ask, or he can ask obviously, but just for efficiency purposes, I think.
Start with the law library. Just see the law library still do it.
You should ask, but don't be disappointed if the answer is no. I think there were issues with, a USB drive is so small and it ends up in someone's pocket, and then it's on the 7 North. And I'm not saying you did.
Is it part of me possible they I ain't got to tell you, they can stick it in, sit there, watch with me to watch the whole video.
You tell, hey, if you can sell it and make them do it, that's great. I'm not saying no. It's not my call. It's not his call. That's 100% the chief jailer's call. And they may have said, we're not doing it anymore. And if they're not, then you come over here and we'll make it happen. Anything else?
No, Your Honor, I'll get paper discovery this week.
Great.
To Your Honor, and then I will, in abundance of caution, put all the digital media on the drive just in case.
Good.
And regardless.
Well, and that would be helpful because if you include that with the paper discovery, then you don't even need to be in. If we can get our hands on a laptop, then we'll let you know when Mr. Pierce is coming over, but we may not need to impose on you to show up with the stuff loaded on a computer. I don't know. I don't want to get in the middle of the technical stuff, but I do want to enable Mr. Pierce to see what the state has.
I have no problem logging in the laptop when he's here. We did that with Judge Ingram on multiple occasions. It seemed to work pretty efficiently.
Good. I think so.
And Mr. Pierce is an ANC recidivist, so he is facing a convicted, a mandatory life without parole sentence.
Okay. And is there a recidivist notice in the docket?
Not at the moment. I intend to file it.
Okay. Mr. Pierce, I'm going to translate that for you. You may already know what it means, but because of your criminal history, the state has the ability to file a pleading, which it sounds like they're going to do, that if you're found guilty, and all of this is contingent on a jury finding you guilty. If they find you not guilty, none of this matters.
Okay.
But it's a big if. And if a jury comes back with guilty, I had mentioned that the maximum possible penalty was life without parole. But if you'd never been in trouble before, that's not a mandatory sentence. Life, I'd have to impose life, but I have the option to choose between life without parole or life. Unless you've got sufficient criminal history and the state files this notice. And if they do that and they've got certified copies of your convictions, then that takes that discretion away from me. And the only sentence you can get is life without parole. And that may be where we end up, but they haven't filed it yet. When they do, we'll figure it out. But it's important that you be on notice of that, because sometimes the defendant thinks like, hey, you know what, if I'm found guilty, it'll be life. That's a long time, but it's parole after 30 years. But if life without parole is the only option, it just may make you think differently about the case. Don't know, but we'll keep you posted. Okay. I appreciate everyone's patience. Mr. Pierce, we'll get you back here either because you filed something we need to talk about, or it's time for you to look at the digital discovery. All right.
So, question before we go. How much do I have, like a certain amount of time to file all the motions that I need to file, or how do that work?
So there'll be a scheduling order that comes out, and we'll need to make sure it gets to you. And that's got a deadline for the state to get discovery. And then you've got a deadline after that, so you can see all the discovery to file motions. Okay. You can always file a motion later on. I just don't promise you that I'll get to it before we get to trial, because you want to avoid a defendant just before trial. It's like, oh, no, I got another motion and another motion. So you're going to want to start filing things. If you already have them here, put them down on paper and start filing them. But you'll get this scheduling order that's got the cutoff where anything filed after that date is out of time, and I can choose to ignore it, and I don't get in trouble with the Supreme Court.
Okay.
Okay.
And question, I know I've been having a conflict with attorneys, so does my time from this day today on forward start me to file my speedy trial? I know it's a certain time frame for you to file a speedy trial. So does that time frame start now, since we have an understanding?
Right. It started from when you were indicted and not now. So you can still file. You can file. Well, I'm not going to give you advice. You should file what you want to file, and we'll work through whether it's a mandatory speedy trial or if it's a discretionary one. But I'll tell you, no one's interested in slowing this down. Mr. Baker is on a trial calendar that starts in a week. And I'm having to slow that down because really you two ought to be tried together, unless someone can convince me that you shouldn't be tried together.
You're going to try it together even if I'm not a citizen?
Yeah, we can try a citizen next to a non-citizen. That's not, the only reason you don't try people together is if there are reasons why there's some evidence that can only come in if they have separate trials. But I leave that up to the lawyers and you to work through that. My default is always to try co-defendants together. And Mr. Baker's case is ready for trial. So if you say I want a speedy trial, no one's going to say, no, let's slow it down. They'll want to move it along. But you file what you want to file, and I promise you we'll work through it. Okay? All right. Thank you, deputies. You can take Mr. Pierce back.
This is going to be a train wreck because he's got the other guy. A lawyer.
Judge, as an update, success.
Good. Given how much time we just worked, you should have everything done. But thank you.
Yeah, working on that.
Okay, so this is his next appearance.
Later, after they like thousands of documents, and they're on our list of your house is getting ready to be auctioned. And yes, I have had some. Now, why?
No, this is from the first. This one's the 1st of April. The one we just watched is from March 4th.
I used to develop or professional, and I was like, okay, what we gonna do today? And they would come in.
I'm not sure what the date of the trial is.
Can we bring Mr. Pierce out, please?
And I don't know how to find out what the date for the trial is. I guess I'm just going to have to keep watch on McBurney's court and try to figure it out. We may have to watch it after the fact, too, because of the Karen Reed trial. So I don't know how we're going to follow this, but I dang sure want to follow it now. And I don't know why the green box is there. It's there through the whole thing. I don't know how to get rid of it.
Hey, Mr. Pierce, come to the podium, please.
This one, they have to keep telling him to slow down for the court.
1 second.
Yeah, two guys.
Finding out about your scheduling order. Okay. Let's get on the record, please, Ms.
Yeah, the other guy has a lawyer. And this one wants to represent himself. They both did this. I don't know which one actually shot the guy. They're both felons. So they both... I've lost track of how many counts of felony murder because of all the felonies they committed in the course of the crime. Okay. Yeah, there's a ghost. That's why there's a green box there. It's picking up a ghost. So, yeah. They're both felons already. So they've got felons in possession of a weapon. And because they robbed him, so it's felony murder. And then they were in possession of weapons. So then they have felony murder because of that. It's like 5 counts of felony murder because of all the other crimes they committed while they did it. Plus murder. So they're going to go away forever. This is it. And he wants to represent himself.
Ms. Rivers, this is 24 SC 003257, State versus Ricky Pierce. Mr. Pierce is in court. He was at an earlier proceeding. He and I had a long conversation about self-representation. I've entered an order allowing him to represent himself or honoring his request to represent himself. Today, we're going to cover 3 things, Mr. Pierce. 1, we need to do your arraignment because we weren't sure if you were going to have a lawyer or be your own representative. I held off on arraignment, so we got to do arraignment. 2, I'm going to, on the record, get you the paper part of your discovery, which you can take with you. And then 3, we're going to talk about scheduling so that your case catches up with Mr. Baker's. So let's start with the arraignment.
Before we can get into that, it's a lot of issues that I had that I want to address before we get started with the arraignment. It's a lot of questions that I have that I need to be answered.
Okay. So why don't you give me an example of one of the questions, and then I'm actually going to decide whether we do arraignment first or your questions first.
Well, the law state that in Hagan versus Levine state that anytime a jurisdiction is challenged, that it must be proven before the case proceeds.
Okay.
And you're trying to proceed with this case without establishing jurisdiction first. That's the law, Your Honor.
Okay. It will work better as you and I are working together on this. If you've got legal concerns, you put them into a motion. So
I have filed a motion already, but Your Honor.
So I'm going to look and see what's in the docket.
It states that a court cannot proceed without establishing jurisdiction first, Your Honor. Okay. This is the law. I'm not saying nothing that's against the laws of Georgia, Your Honor, or the United States.
She can't take down, we talk about that. She's trying to take down everything you said.
Right. So pause. Just hold on, Mr. Pierce. I'm looking in the docket here, and I'm not seeing that you filed, and it just may not have made it yet, that you filed a motion challenging jurisdiction. But I'm happy to let you know right now, I'm real comfortable with the court's jurisdiction. That doesn't mean I won't.
Your Honor, it states that the proof of jurisdiction beyond reasonable doubt is asserted. I'm the one asserting jurisdiction here, Your Honor. So that means I have to prove jurisdiction, but you got to give me the opportunity. If you don't give me the opportunity, you're violating my rights, Your Honor.
What's in your mouth?
paper.
Oh, okay. I just want to make sure everything.
But yeah, the law states that the assertor establishes jurisdiction is to prove jurisdiction, Your Honor. You're not letting me do that.
Okay.
You're not.
Okay. Okay.
Why would you put a penny in your mouth? That's gross. You know where pennies have been? That's nasty.
Gotcha. So one, we got to speak slowly, and two, now I'm better understanding. You're saying you want to prove jurisdiction?
Yeah, I'm the assertor. Can I just read my question? Just go through it's not that long.
Okay. You said a whole bunch, but if it's not that long, how about I listen to you?
Your Honor, it's a lot of things I'm not understanding right now, and it's a lot of questions I need you to answer. So I can better understand what is going on up until this point, Your Honor. Like, hey, I changed the court jurisdiction on March the 4th, 2025, and I also filed a motion that's right here I have signed by the clerk saying that it's been filed. But this is the motion right here that I have filed. I have here something, copies back and everything. And plus, the courts are still trying to proceed with my case when you guys lack subject matter jurisdiction. Plus, it states in Louisville versus Motley, if any tribunal find absolute proof of jurisdiction over a person or subject matter, the case must be dismissed.
Okay, slow down. I'm gonna let you keep reading. Just slow down so Ms. Rivers can get what you're saying.
And also, Your Honor, once jurisdiction is changed, it is to be proven not by the courts, but by the party attempting to assert jurisdiction, which will be me. Your Honor, the burden of proof lies with the assertor.
Okay, I'm now finding, it just wasn't listed as a motion, but I do see it's in the docket right here, something that you filed. It's entitled Pro Se
with a prohibition.
Right, got it. So I've got that. I will rule on that. I'm going to give the state a chance to respond, but you you filed it a couple weeks ago, and so I'll get input from the state on that, and then I do owe you a ruling on that. That does not prevent us from doing the arraignment.
It does, Your Honor, because the law states that anytime a court jurisdiction is challenged, it must be proved. It must be proven before the case can proceed, Your Honor.
Okay.
So I challenged the jurisdiction last month, March the 4th. So that means that you have to set a court date for me to prove that you lack subject matter jurisdiction. That means I have bring my evidence, the state bring their evidence, show jurisdiction, and I'm not a statutory entity, so therefore statutory law don't apply to me, Your Honor.
Is the writ of replevy, is that your challenge to jurisdiction, or is there
that's to go with my writ of prohibition.
I love this, Judge.
Okay. Let me see if I got
my
that.
writ of prohibition. I filed 2 motions.
Okay. Let me just take a look here.
I have a lot of questions that I need to be asked.
As long as you read slowly, we'll get through that. Okay, I think I've got your writ of prohibition also. And is that the challenge to jurisdiction?
Is that for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction? Yes.
Okay, I see that. It says for fraud. Yep, they're all there. All right, so you filed them. I'm making a list here of things that I need to work on, and then I'll need to let the state respond. The way it works, if you file a motion, the state gets a chance to respond. Once I have both sides, then I can rule on that. Okay.
I mean, but you're still trying to proceed with the case, Your Honor, when we haven't established. You trying to get me to plead when this case is supposed to be at a standstill when I changed the jurisdiction March the 4th of last month. So that means you have to prove jurisdiction before you can make a plea on this, Your Honor.
I'm fine delaying the arraignment while we work through this. We don't have to do the arraignment today. I can hold on to the discovery and get you that another time. If you would prefer that I let the state respond and then I rule on it, we can handle it that way. Is that what you'd like?
I would like if we can just answer these questions that's had right in front of me today, Your Honor.
So then don't read the motion anymore and tell me what are your questions.
I wasn't reading the motion. I read what I have wrote down, my issues I have.
Okay, but ask questions instead of telling me about these cases.
Your Honor, I am on, let the record reflect that this is the defendant, this birth certificate, which is the person slash persona, which is a legal fiction, also a statutory entity.
I can't understand.
Okay, I need you to slow down a little bit. So,
let the record reflect, Your Honor, that this birth certificate is the defendant. I'm physically showing the birth certificate. Everyone in the courtroom that this is the defendant, and I am the defense.
Okay.
Your Honor, I am only here in this courtroom by special appearance on the threat and duress to administer affairs of the All Cap Trust, which is his birth certificate.
Okay.
As a sole beneficiary.
Stop. You told me you had questions. Tell me.
Yeah, I'm getting to it. I'm just introducing to the question, Your Honor.
I want you to go straight to the question now.
Your Honor, is this courtroom a court of records?
Okay. What's your next question?
Is this, you can answer it? Is this courtroom
I want to know what your questions are.
I'm asking the question, Your Honor, is this courtroom a court of records?
So I thought you were going to share with me what the questions were. I didn't tell you if I was going to answer the questions. You said you had a bunch of questions.
So you're going to have me ask questions that you're not going to answer, Your Honor? That's not fair.
Well, don't ask the questions then. You don't have to ask the questions. You said you wanted to ask your questions, and I'm happy to hear them. If it's appropriate for me to answer them, I will.
So you don't think me asking is this court of records appropriate?
I didn't say it was appropriate or inappropriate. I just needed to know what your questions were. And if they're ones that I should answer right now, like what time is it? I can tell you, 3:51.
Yeah, and I'm asking something very simple, Your Honor. Is this courtroom a court of records?
All right, and what's your next question?
Your Honor, is your courtroom a court of records? I can't get
That
past
seems like
these
the first
questions.
question.
Need to be answered before, Your Honor. This question need to be answered for me to proceed, Your Honor.
Okay, tell me
I'm
what
trying to get an understanding. If you're not trying to help me get an understanding,
tell me what you mean by a court of records.
is this a court of records? It's simple.
I don't know what that means.
Is this courtroom a court of records?
I don't know what court of records means.
Do they record and proceed on everything that's happening in this courtroom? Do they record and document everything that's happening in this courtroom?
I don't know about everything, but as long as you're speaking slowly and clearly, then things are being taken down. What's your next question?
Is this Fulton County courtroom a court of records? The same question you're not answering, Your Honor. You're trying to dodge the question.
No, I'm not. I want to make sure I understand the question.
Is this Fulton County courtroom a court of records?
At times it is.
And you sure this courtroom is a court of records?
If court of records means we take down what is said in court, then yes, sometimes this is a court of records.
For the record, Your Honor, I go by Ricky DeMond Pierce, all lowercase letters, nothing more, nothing less. Again, I'm here by special appearance on the threat and duress to again administer affairs of the All Cash Trust as the sole beneficiary and a shareholder of the trust, which again is this birth certificate. Okay, I'm also the executive of this estate, and I'm not the living person, not the person or persona, which is a statutory entity. I'm not the all caps legal official on my corporation. I'm the living man, and I have proof signed by your government agreeing to the same.
So what's your next question?
Your Honor, before we could proceed with this matter, I have a few questions I need for you to answer. First, Your Honor, are you practicing color law behind the bench?
I'm not sure what you mean.
Are you practicing color law behind the bench? Because Title 18 U.S.C. Section 242 clearly states that you are committing a felony if you are doing so. Title 18 states, whoever, under color of any law, statute, ordinance, regulation, or custom willfully subject any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured by and protected by the constitutional laws of the United States shall be found under this title or in prison not more than 1 year or both. And if bodily injury results from acts committed in violation of this section, or if such acts include the use, attempted use, or threat of use of a dangerous weapon, explosive, or fire, shall be found under this title or in prison no more than 10 years or both. And if death results from the acts committed in violation of this section, and if such acts include kidnapping, attempted to kill, shall be found under this title or in prison for a term of years or for life or both, or may be sentenced to death. Now, my question, let the record reflect that no legal or lawful matter can proceed without jurisdiction, Your Honor. We both know this.
Right. So we're going in circles. We're back.
Let me finish. Your Honor, my question to you is Your Honor, for the record, is this matter a criminal matter or a civil matter?
What do you think?
I just want to answer.
You're standing there in handcuffs. You're wearing a jail outfit.
Honor, can you please answer the question for me, please?
I'm answering with a question. What do you think? lowercase
I don't know.
r,
I don't know,
lowercase
Your
p?
Honor. That's why I'm asking. I don't know.
think you
That's
do
why
know.
I'm asking.
What's your next question?
Is
Ask
this,
me
Your
a question.
Honor, Your Honor, for the record, is this matter a criminal matter or a civil matter?
Ask a question you don't know the answer to.
I don't know that. I'm telling you, how you gonna tell me what I know, Your Honor?
Well, if it were a civil matter, would you be having to use the restroom in front of everyone else?
Oh no, that's why I'm asking you, Your Honor. I'm coming to you as fast as I know how, Your Honor, and humble as I know how. I don't know. That's why I'm asking the question.
Okay. What's your next question?
Your Honor, for the record, is this matter a criminal matter or a civil matter?
Oh my God.
Okay, that would be your next question. That's one you already asked.
Why we can't pass this question, Your Honor? Because I lack knowledge to understand what is going on, and I'm telling you this, and it's my authority to let the court know when I don't understand something.
A fair point. I want you to let me know when you don't understand. We already covered that when we had our Feretta hearing. We talked about what kind of case it is and the penalties you face.
I said, is this a criminal matter or a civil matter?
How much more time do you need? Because you got about 3 minutes before I'm going to bring someone out here that we can move the case along.
Your Honor, I just want you to answer my questions because I lack knowledge to understand what's going on. I'm just trying to keep caught up to date to understand what is going on.
Okay.
There's no harm in that, Your Honor.
What's your next question?
It's the same question. Before I can get to the next question, I have to answer this question.
Go to the next question. You just said you're not gonna answer.
Your Honor, for the record, is this matter a criminal matter or a civil matter, Your Honor?
All right, we're done. I will bring you back once the state has responded to your motions, and I will likely be entering an order that lets you know my thoughts about jurisdiction. Once I've done that, you can choose to participate in an arraignment, but you do need to understand that in a criminal case, that's a clue.
So this all criminal matter. Then why you can't answer the first time, Your Honor?
Why are you asking in the first
Because
time?
I'm trying to get. I just told you I'm trying to get an understanding.
So let me finish. So you understand that in a criminal case,
So this is a criminal matter, for the record.
such as yours, if you choose not to
Is this a
participate,
criminal matter or a civil matter, Your
you
Honor?
need to stop interrupting, okay?
I'm trying to understand something. It's my right to, if I don't understand something, to bring it to your attention, Your Honor. That's the law.
Well, it's not the law, it's how you're choosing to proceed. If you decide not to participate in arraignment, I'm authorized by law to enter a plea of not guilty. And that's what I'll do. So when I see you again, we're going to try again.
So you're going to violate the laws to when it states that a case cannot proceed without establishing jurisdiction first. So you're just going to ignore that.
Nope, I'm going to rule on your motion. And after I've done that, then I'll bring you back for arraignment. And you can choose to participate in it or not. I'm just letting you know in advance so you're not disappointed.
I'm not going to participate in it until you establish jurisdiction on me first. That's the first thing first. We're not going to skip the process. This called due process of law for a reason, John.
It is, and that's why we're not
And
doing
in
it.
Hagen versus Levine, it states that any time a jurisdiction is challenged, is to be proven before the case can proceed. That is the law. That is not nothing that I made up, John.
Okay, you may be misapplying it, but I'm not disagreeing.
I'm not just I done read it 1,000 times, John.
Okay, well then you know it. So that's why we're not doing the arraignment today. I'll take care of establishing jurisdiction. And once I've done that, I'm comfortable that I've established jurisdiction, we'll bring you back for an arraignment. You can participate or not, but we'll have cleared that hurdle that you.
If you haven't, I'm not going to participate. If you can't establish jurisdiction over my case first, why would I participate?
You don't need to participate. I'll bring you out. You can say no, thank you. We take you back there. We bring the jury in.
I mean, Your Honor, I have issues, and it's
You do.
yeah,
You do.
yeah, and we both do, Your Honor.
And my responses, do I address them to, as Mr. Pierce has recognized to start the day as lowercase r, P, the rest of his name, because he signs all of his motions with uppercase R, uppercase P, uppercase.
No, I don't. I do uppercase or lowercase everything else. Dash. I don't have an signature. I have an autograph.
It's just different. I respect that. I just was curious. It's different than what he.
Let me show you.
I got it right here.
Right. No, I'm looking at it. It's capital R, capital B.
No.
Oh, yes. But that's all right.
Is that all caps?
No, it's not all caps, but you capitalize each.
Yeah, I
Good word.
This is all caps. Is this your handwriting?
What?
See, that's all caps.
Oh, that's awkward.
He wrote his name in all caps.
All right.
Is that in all caps?
So how about this, Mr. Pierce? I'm going to agree that you have written it in different ways, and I'm really not going to get hung up on that.
I'm not all, you know, like I got the paperwork right here signed by the government saying I'm not a part of y'all, and it's on file with the office. It's filed in office. My paper right here shows that I'm not the all caps legal official signed by y'all government.
Good.
Signed by y'all government saying I'm not the all caps.
I will not use all caps. I will not use all caps.
Signed by you guys government.
You guys, okay.
Because I'm a national, not a citizen. Y'all are citizens. I'm not.
I remember you establishing that before. We don't need to cover that again.
It was very much that I present it at every court because it's for the record. It's my job to put it on the record, Your Honor.
Okay, it's back on the record. We're incorporating in this hearing what you put on the record at the last hearing, and we'll do that every time. Anything else you want to cover? Because I'm happy to give you this discovery, but you can't have it.
I don't want to proceed until I get my question answered, Your Honor.
All right. Why don't you do this? If you want to put them in writing, you could file them and I can get you those answers. But we're wasting not your time or mine, an important conversation, but there are a lot of other people here who are stuck while you ask questions like, is this a criminal matter or a civil matter? So
right, because I don't understand.
Okay.
And I just want to ask you where is the problem just answering the question, Your Honor? Because I let the knowledge know.
Okay. I feel your lack of knowledge, and I'll bring you back after I've responded to the motions you filed. That's the way we're going to interact here. If there's something you want an answer for or ruling on, you need to file it. And you know how to do it. You did it well.
Wait, the best part is after he leaves.
I'll keep your discovery warm and dry in my office.
Well,
this judge is amazing.
So would you just continue this court date or something?
Yeah, we can't do the arraignment today. You've helped me understand why. You want me to establish.
Because you can't proceed with my case until you establish jurisdiction over my case, Your Honor.
That's right.
That's the law.
It is the law.
So what's the problem with me asking the question to better understand what's going on?
Because, I don't even have jurisdiction yet. Let me establish that. Then I'll be in a position to have a conversation with you.
And we're not talking about statutory jurisdiction. We're talking about the Constitution jurisdiction.
We're talking about whatever jurisdiction I find. Okay? I'll see you soon.
This man is 41 years old and acts like a child.
Bye, Judge.
That went differently than I expected. Really? I thought just by letting him vent that first time, he's sort of like he purged himself. Clearly not.
Your Honor, I have an announcement on Mr. Estrada's case.
Yes, let me turn to that calendar. This was just a fun little carryover from this morning.
Oh, I love Judge McBurney. He's just, I love it. Like as soon as he's out of the room, everybody busted out laughing. Yeah, so I need to find out. He said that he would put in not guilty. So I don't know if he tried to arraign him again or not. But that was on the 1st and it's the 7th. So I don't know if he brought him back or not. So I need to watch McBurney's court and see if there's another appearance. But yeah, we definitely need to follow that because I need to know what happened. I would not be surprised if he gets aggravated and just finally says, fine, give me a lawyer, because and then so McBurney wouldn't answer the question because the guy knows the answer. And then he says, in your criminal case, he answered the question. He just didn't say, yes, this is a criminal case. He said, in your criminal case. So he answered the question. And he's still saying, you didn't answer the question, Your Honor. You didn't answer the question. He's just being a sob turd. That's all. He's just doing what they all do. He's just, I don't know if he like watched Darrell Brooks and was like, hold my beer or what. But, oh, did he? I didn't hear him say that. Yeah, that's a clue. Yeah. So, I don't understand how someone can do that and then actually plead not guilty. It blows my mind. Well, it blows my mind how anybody can do that in the first place. But to do it and then plead not guilty and go through a whole trial, I don't. You might as well say, okay, I did it. I'll take a plea. Because he's done now. He's a felon, and because he's a felon, those charges just stacked up and stacked up and stacked up because, I mean, murder during a robbery already becomes felony murder, and then he's a felon in possession of a gun, so that is another charge of felony murder. So, but no, he wants to represent himself. And that poor court reporter, she's probably thinking, I hope I don't work on the days at this trial. She's going to call in sick. Yeah, I know. I hate that. Florida's not like that. Although Florida is, some courts, you can, in Florida, some you can just go to the clerk of court website and find docs, and others you have to submit a request. I don't like submitting requests because I feel like I know it's legal, I know FOIA, I know all that, but I still feel like it's none of my business because I'm just Joe Schmo with a computer, you know? So I don't like requesting things, but I certainly don't have the money to pay for things like that. So it aggravates me that they charge. But I get it. I mean, they need money for stuff, so that's how they get it. I understand that. Yeah, she absolutely is gonna call in sick. Yes, disgusting human being. Absolutely. And, you know, the other guy has a lawyer, so he might plead guilty. Who knows? Yeah, I saw some of the articles. I played a real quick news segment at the very beginning. I don't know if you saw it or not. Just to give, you know, a little backstory. It wasn't much, just that, you know, he got shot. And that dog is so pretty. It looks like it's a puppy. It doesn't look like it's a full-grown dog yet. And like I said, I have no idea what happened to it. Hopefully it got back with the family. Because, Tequila, his name is Tequila. He looks like he's a pit bull or a pit bull mix. It's a really cute dog. So that's so sad. And I don't know if the object was to steal the dog or if they knew the guy and it was a beef or, oh, good Lord. I know, I was like, what does a Revolutionary War have to do with anything? We don't need the whole history of the founding of America, okay? We all learned that in high school, all right? We don't need it again. That's nothing to do with the fact that you killed a man, okay? Good Lord, $750. The defendant's name is Samuel Harris Jr. I forgot his middle name. The dog's name is Tequila. The defendant's name is Ricky Pierce. Darn it. I forgot the other guy's name.
New at 6, another man is behind bars tonight in connection with the shooting death of a man who was walking his dog in southwest Atlanta. The DeKalb County Sheriff's Office says deputies arrested Ricky. New at 6, another man. New at 6, another man. Is behind bars tonight in connection with the shooting death of a man who was walking his dog in southwest Atlanta. The DeKalb County Sheriff's Office says deputies arrested Ricky Pierce on Friday. Pierce faces charges including murder, aggravated assault, armed robbery, and more. Brandon Baker was also arrested back in April. He faces similar charges. Samuel Harris was shot and killed on Mitchell Street Southwest just after 8 p.m. back on February 5th. His dog Tequila, seen there, was stolen during that incident. Leah Harris, his wife of 15 years, described him as a family man with a calm spirit who had lived here in Georgia for 30 years. Authorities are still investigating what happened that night. If you know anything in this case, you're asked to call Atlanta police.
So Ricky Pierce and Brandon Baker were the two guys, and Samuel Harris Jr. is the deceased. Why are we talking about Ricky? I can't even say it. Ricky Tiki Tavi. Because of Ricky Pierce? From now on, he's Ricky Tiki Tavi? Okay. Okay, guys. That's all I have for today. And tomorrow we're back with... Oh, I don't want to. Linda's boys are going to testify tomorrow. I really don't want to watch these. Well, they're adults now, but... Yes, the dog was stolen. And I don't know if they did it to steal the dog. I don't know if, I don't have details. That's all I know. That's all the only backstory that I know. And I didn't know that before I saw the clip. I just found that clip so I could show you guys the backstory. And that's all the backstory I know. So I don't know if they did it to steal the dog. I don't know if it was a personal beef. I don't know if they just did it to rob him and they went, ooh, let's take the dog. I don't know. So, but if they did it to steal the dog, that makes it even worse in my eyes because dogs are people. Your dog is family. You don't steal somebody's dog. That's just wrong. I know my priorities are twisted, but you guys are animal people too, so. Okay, bye guys. I'm sure I will see some of you elsewhere later on YouTube somewhere. And I will see you tomorrow. And we will do Phil shortly. Phil Spector for about an hour in the morning. And then we will do Burned and Battered and have to listen to those poor boys recount the worst day of their life. And then we're going to hear what the defense has to say. So, bye. Love you guys. See you later. Have a good rest of your day. Bye.